today is the page 14. 14, request for entry of default. 14, 1-4. Request for entry of default meaning I'm receiving any summon. After receiving the summon, didn't answer, just getting entry of default. Entry of default meaning judgment, but not finding. Just I give up the legal document, and then I receive it for the request for entry of default. Okay, title is the request for entry of default, mark here, or clerk judgment. Clerk judgment is entry of default and then clerk judgment. I don't wanna, or you cannot clerk judgment, just judgment by court. That one is the court judgment. Doesn't matter, all the same thing. Entry of default, one for clerk judgment, one for court judgment. Clerk judgment is the court clerk sign on the paper. Court judgment is judge sign on the paper. But the same thing. Number one, to the clerk on the complaint or cross complaint file. Complaint file date. Complaint file date meaning I file request for judgment. To date, 10 days ago, something. By name, by my name. My name meaning plaintiff, landlord, C1, and the default of defendant, and the default of defendant. Defendant against the defendant, name, defendant's name, but not single, normally husband and wife, or husband and wife and any other persons. All the person name here. D. I request a court judgment on the Code of Civil Procedure, Section 585B, 585C, 989 Act, against defendant judgment. Defendant judgment, defendant's name, all defendant name here. E. Enter clerk's judgment. If the clerk's judgment for number one, for restitution of the remedies only, and issue a writ of exclusion on the judgment. Writ of exclusion meaning I can do at any action I can do. I request for material or bank account, something, everything, I can do it. Including the judgment, all tenants, sole tenant, named claimant, and other occupants of the premises. The pre-judgment claim of right to possession was served in compliance with the Code of Civil Procedure section 415.46. Number 2, under Code of Civil Procedure section 585A, complete the declarations under Code of Civil Procedure 585.5 on the reverse. 3, for default previously entered. 2, judgment to enter amount that didn't pay to the rent, past due amount, demand of complaint, and then credit acknowledged. Credit meaning for the I have paid security deposit. That one is security deposit, and then balance. Amount is the a few months around $3,000. Credit acknowledges $1,500. Balance is $1,500. Statement of damage. Statement of damage meaning special, general. I didn't pay any rent. And then to C, interest, D, cost, E, attorney fee, total something. Daily damage were demanded in complaint at the rate of something. For example, I paid the rent is $2,000 per month, and then daily damage meaning $2,000 per 1 month, and then 1 day is around $67. That amount is per day beginning. Per day beginning meaning I didn't pay the date. 1 day amount. 3, check if filed in unlawful detainer case, legal document assistance, or unlawful detainer assistance. Information, and then reverse date, and then type of print name, signature of print name or attorney. That's it, that's all. Next page. Legal document assistance. Legal document assistance meaning LDA or unlawful detainer as assistance. Unlawful detainer assistance, professional business or professional code 6400 Esquire at legal document assistance or unlawful detainer assistance did or did not for compensation, give advice or assistance with this form. If declaration, if declarant has received any help or advice for pay from a legal document assistance. If you are legal document assistant, LDA, meaning paralegal, and then information, assistant name, street address, city and zip code, C, telephone number, county of registration, registration number, expire on. Number 5, declaration under Code Civil Procedure 585.5 for entry of default under Code Civil Procedure 5858. This action A is or is not on a contract or instrument sale. Instrument sale meaning paying every month to pay, that's the instrument sale. Or goods or service subject to Civil Code 1801, it expires. B is or is not on a conditional sale, contract subject to Civil Code 2981, Esquire, subsequent. If you don't have any action, next one, 6. Declaration of mailing. A copy
Contract.
A copy of this request for entry of default was A. Not mailed to the following defendant whose addresses are unknown to plaintiff's or plaintiff's attorney name. B. Mailed first class, postage prepaid, in a sealed envelope addressed to each defendant's attorney of record, or, if none, to each defendant's last known address as follows. Mailed on to specify name and address shown on the envelope. I declare on the penalty of perjury under the laws of the state of California that the foregoing item 4, 5, and 6 are truly correct. Date, title of his name, signature of declaration. Number 7, memorandum of cost. Memorandum of cost meaning required if money judgment requested. Cost and disbursement are as follows. A. Plus filing fee. Normally filing fee $250 or $499. Process service fee. Process server meaning somebody delivering the document to the defendant. Normally $75 through $100. Other nothing. Total, something like that. Costs and disbursement are waived. And I am the attorney. I am the attorney, agent, or party who claims these costs to the best of my knowledge and believe this memorandum of cost is correct, and these costs were necessarily incurred in this case. I declare on the penalty of perjury under the laws of the state of California that the foregoing items 7 and true and correct. 7 meaning how much total should I pay? That one. How about next page? Next page is the number 8. declaration of non-military status. Non-military status meaning defendant is not soldier. If the soldier, we cannot lawsuit against the soldier because he should move so many places. Number 8, declaration of non-military status. No defendant, respondent named in item IC is in the military service of the United States as defined by either the service members Civil Relief Act. Okay. I know that no defendant, respondent named in item IC 1C is in the U.S. military service because number 8, the search result that I received from SCRA, the COSD, say the defendant respondent is not in the U.S. military service. Defendant is not the military service. I am in a regular communication with the defendant, respondent, and know that just this one is marked here. Next. C. I recently contacted the defendant, respondent, and they told me that they are not in the U.S. military service. I know that the defendant, respondent was discharged from U.S. military service on or about. E. The defendant, respondent is not eligible to serve in the U.S. military service. They are incarcerate business entity. Other, just to mark one. One mark is number A or B. The search result that I served for something say the defendant, respondent is not in the U.S. military service. Or B, I'm in regular communication with the defendant, respondent. No, they are not in the U.S. military service. Reasonable is number B. Okay, and then the bottom, I declare the penalty of perjury under the laws of the state of California that the foregoing and 8 is true and correct. Date, name, signature. That's the unlawful detainer. You're finished. If you file this one normally after 2 weeks, you can get a judgment. Next page is judgment. Judgment unlawful detainer. You can receive immediate judgment. Judgment unlawful detainer by club, by default, after court trial, by court, possession only, defendant did not appear at trial, normally by club or by court. 1 or 2, just you mark. Number 1, by default. By default meaning I didn't answer, even the other parties send me any request of any summon, I didn't answer. Defendant was properly served with a copy of the summon and complaint. Defendant was properly served, was served. He receiving meaning. B. Defendant failed to answer the complaint or appear the defendant the action within the time allowed by law. C. Defendant default was entered by the club upon plaintiff's application. D. Club judgment for possession only of the premises described on page 2, item 4. Number E. Court judgment. The court considered 1. Plaintiff's testimony and other evidence. 2. Plaintiff's or other written declaration and evidence. Number 2. After court trial, the jury was waived. Jury's trial, the court considered the evidence. After court trial, A. The case was tried on date and time before name or judicial officer. B. Appearance by plaintiffs, just the plaintiff's name, each name. Husband and wife, in case of husband and wife, both names. Plaintiff's attorney, he has attorney, number 1 or 2. Continuing attachment 2B, Form MC 025. Defendant, name each. So name defendant is all the name here. Defendant's attorney, if he has attorney, put right here. Continued on attachment 2B. 2B meaning plaintiffs. C. Defendant did not appear at trial. Defendant was properly served with notice of jury, notice of trial. Even defendant was properly served. Next, that one is here. Even all the documents he received, but they didn't answer. That one. Number C. Defendant did not appear at trial. Defendant was properly served with a notice of trial. The statement of decision was requested. Next page. Page 18. Judgment is entered as followed by the court, the club. If you request for court judgment, is court marked here, or trial, club judgment is marked another one. 3 parties. Judgment is for plaintiff's name here, and against defendant's name here. B. full defendant name each, meaning for the all the person, all defendants name here. 4. The party entitled to possession of the premise located at street address, apartment, city, and county is plaintiffs named in item 3A, defendants named in item 3B, defendant list on attached form UD-110P in item AB1, number 6. Amount and terms of judgment. A. Defendant named in item 3B above must pay plaintiffs on the complaint. B. Plaintiffs is to receive nothing from defendant named in item 3B. Defendant named in item 3B is to recover costs and attorney fees, something. How much? Number 1, past due rent. I didn't pay. Defendant didn't pay for the past due amount, rent. Hold over damage, attorney fee, cost. Cost meaning court fee, total judgment. C. The rental agreement is cancelled. The lease is forfeit. 7. Conditional judgment. Plaintiffs has breached the agreement is provide habitable premise to defendant is stated in judgment. Unlawful detainer, habitable premise meaning house or something. Habitable premise to defendant as stated in judgment. Unlawful detainer, habitable premise attachment. 8. Judgment for partial eviction. The partial eviction is issued as stated in judgment. Unlawful detainer, partial eviction attachment. 9. Other. Continued attachment 9. Date and judgment officer. Judicial officer meaning judge by court or club. Sign here. That is a judgment. Okay. Break time. 10-minute break.
Okay.因为你吃了吸血的药，为什么是吸血的药？我现在喝的不能。开胸了，做了一个什么？心脏换瓣膜，心脏换瓣膜，对，就那个心脏上面做的手术，对，心脏把那个瓣膜切掉，换了个机械的。这个动不动跳？对。 哇，你们机械的，这样就喊谈男朋友。你就喊谈男朋友吧。
不当我谈。
你就是挺胆大的哦。
也不当我谈。
你跟他睡觉。
也不当我谈。
你这感觉有什么感觉呢？
比以前更有力。
是吗？什么？就是他跳得很快。
你听听，就是那个就是秒针的声音。这个位置，对。
刚开始听得很清楚，现在怎么不跳了？
不跳。
你是不是在那屏住呼吸？
没有啊。
没有。
我动了。
你不要动，不要动，动了以后它跳得很快的。可以了。就是那个，机械啊，对。
然后学题目
很起来。
然后
原来人家不是
之后就更厉害。
身体很有力量。
对，原来是感觉就是心脏帮动力不全，然后就会导致就心脏回流，血管回流，
血管
对，然后心脏跳就很
力量的，
以前是
人就会有精神。
现在是砰砰砰。
因为你吃了吸血的药，所以你就会流鼻血。
不是因为我这个换了铁的瓣膜嘛，机械的瓣膜，换完之后他要是不实行，然后血就容易粘在上面，容易形成血栓。就血栓都危险。
就把血栓就容易
就容易贴在那瓣膜上。因为那甩掉了呢，甩掉之后，它要是掉到血管上，血栓掉到心脏上，心梗，然后血管血栓，所以吃这个就是抗凝药吃。然后我现在就是划个口就出血。
就出去不止出来。
就这里昨天坚持可以划个口，然后就出血不止。一点点，我就走起来了，比较好看。
你别抠啊！
因为我今天回去再做。
好看呐。
这啥？
那个这个不是一个啥？
不是一个啥？
那这个红的吗？有点色嘛。这个要黑一点那个，这个颜色好看。我以为是俩颜色，一个颜色的呀。这两个是一样。
这个多涂了一点。多涂了一点。
这个要亮一点。
对，就胶布一样。之后两胶就是跟吸铁石吸的，要吸铁石也带。
是猫眼。
猫眼我没吸出来，我没带吸铁石。
用个铁就可以。
对，没带吸铁石。
铁筷子可以。
不行，对，
有细碎的铁。
它里面是磁粉。你指甲多好看。
你长身高。
我早上有 你看我这个小程序是说的，
我很喜欢做美甲。做美甲就是你不觉得闷的很难过吗？
做完就
闷吗
不？喜欢，但是做上去就是歇尿的时候，好凉。
你看做的时间，因为之前在国内也做嘛，做了一段时间，然后就这个指甲，然后你要不做就跟那个裸奔一样的感觉，像内裤的那种扇风漏气。然后做了之后，只要你不做它就，只要你掉了就啪就那种感觉，像衣服裸的。后来我就不想做了，每次都有这种感觉，就要掉了它就要去做，掉了就要去做，很难受。然后后来我就做了，
你不做的话，还预约，
然后很麻烦。
还贵。
对，太麻烦了，主要是。今天可以去做一个，做个黑的，做一个黑色的，可以做一个青春靓丽一点的。
你发现没？就是越小的孩子，年纪越轻的孩子，越愿意做黑色。
为什么？就是他会有点叛逆。
然后在你们家就会做粉色的，我现在就喜欢做粉色的。
粉的呀，青春靓丽的，
做粉
然后
色的。
颜色淡一点啊，红色的、淡红色啊。
我就愿意做红色。
就跟你年纪了就做黑的啊，颜色很深的那种，
对，是没错。
个性一点。
我现在口红愿意涂黑的。
黑色口红，
深色的、棕色的。
好看，喜欢。
好看，显牙白。
棕色。
粉色就是显牙不那么白。
哦。
粉色它不是那种跳眼的颜色，就显牙不那么白。就是它把淡红色会也挺显牙白。但是那个。
橙色的会好一点。
就小黄。
橙色小黄，小蜡黄。
显脸黄，然后牙也黄，我感觉一笑一样，焦黄多恶心。
焦黄色。
多恶心。然后我就涂那口红，然后我脸就是画完那个画脸涂，画的黑一点。然后那个一起涂那小哥那个说，姐姐的牙好白呀，不像咱们牙就是不黄。因为有的可能是我涂的黄，涂的。
你可能就是你涂那个口红显得很白。
脸底色不涂那么白。就我脸比牙白。
你脸比
对，然后脸涂黑一点，它就显得牙白了。
你太可爱了。
我跟我男朋友去逗他，我去那边的，我去逗他，我跟他学习艺。不要这个说我。但是我是这样子的。最后我是怎么做到就是630米？我说你不是说就是做到舌头顶到这儿，然后我说你伸舌头，他舌系太短，他真的是那种。
他舌头只能那么短。为什么？
因为他这个弦儿是它就特别短，就是抻着，然后舌头伸出来的时候，它是一个就是这个弯的。
因为那他就是学英文会很好。
他那个舌系特别短，你看我们不能看看到这儿。
跟我也是啊。
他不行，
在这里。
他这个带一点，他就一点点，他就在这。
没了。
对。
真的。那他是个舌头讲英文语言天赋会吗？
他说话都就是
有点突兀。
没有呛水。说他什么词，我上面是诗。这么能说他诗？要不然说
那他讲英文的话，可能他也有点，就是
讲英文一股澳洲口音。
澳洲口音。澳洲口音就是他那种，可能没有卷音。
不知道，就是那种澳洲口音。就听他说话，就是虽然说我英语不行，但我听力行，我就觉得他说话不标准。
有点澳洲味道。
就没有
外地人
那么标准。就是他们美国人说话就是特别快。我发现美国人说话特有意思，就是 我语感特别强，就是人家说什么，虽然说大家听不懂，但连起来，我不知道你懂什么意思。
你太厉害了。
但我不说，我真的不懂他什么意思。
那你可以跟你的那个爸爸，比如说聊着聊着，然后他要不教你。
行，就是他是那个消防员，然后他挺早退休的，他美国消防员不是学历很低，就是跟学历高的人聊天，就是这个词你不懂，他会用电话一些别的词替代。他这个词你不懂，他就不会唠，
他就不说话了，他不说话
他
了。
就不会唠，他就换下一个。他说啊，好吧，就没了。然后别的人你去跟他讲这个词不懂，他说这个词会，比如说方便的或者什么easy，那这明白了，明白了。
就是他的词的表达就是简单一点，复杂一点，他们不会说再简单一点，他就说两句，就像我们说话
他
一样。
只是一个词，没有替代的。
那好吧，那他就好给小朋友让他学习。
他们消防员不需要太多的学历，就是卖力气。你看我们国内的消防员可厉害了，
都要技能，然后学历很高。
他们不要，他们只要卖力气。
只要你愿意去就可以。
对，然后他们就是他那里特别重的东西，他只要卖力气。
他退休了现在。
1万多，然后给他老婆一半，剩下1万自己花。我忘了。
退休金1万，然后给他老婆1万。
给我儿子一半。
然后那他如果结了好几次婚，就1/3、1/3。
比如说他给上一个老婆一半，然后就说5000嘛，给我妈就是他就12000，2500。然后再离婚就2500的一半，再离婚2500的一半的一半。
那他第一个老婆，那他退休很高。
所以我说嘛，我说你为啥想不要跟他结婚的话，他比如说要跟你离婚，你最多了，你这几个妻子里面最多。
大姐是吧？
对。
但是我不跟他结婚，但是我不跟他结婚。
我感觉我跟他结婚要比那个就结婚要强一点。为什么？
没有办法喜欢他，跟他在一起的人。
我感觉啊，就是
我喜欢舒服，我不喜欢他听。我觉得他还 OK，但是我不喜欢有一个婚姻存在，你就要束缚自己。我好没有自由，我不从坟墓里爬出来。就大家让你没有就会向往那种婚姻，但是
我不向往，我一直也不向往。但是我遇到这个小朋友之后，
就有感觉，
有种想
家的
那种感觉，就不是说那啥，不是说我图他点什么，就觉得跟他就是什么都聊得来，挺好。我以前从来没有过。我以前真的从来没有。
他就想娶你吗？
他说可以。我说可不可以？行，就是可不可以都无所谓。我主要是想，但我现在不想。反正我现在努力还要等好久。我估计到一个可能就上头那一瞬间想结婚，可能到后来我就不想结婚。
到时候再说嘛。
结婚多好，不结婚一辈子大姑娘，结婚就是20了。
不是，是这样子的，人嘛总要有一个完整的过程，就一定要有个参考婚纱啊，然后拍个留念啊，拍个照片啊。我觉得一定要跟心爱的人去做一些这样的事情，人生才可完美。其实一直在等这个人的出现，但其实很难，很难。
不急，有的是时间。
没事，不着急说让你慢慢来，会有一个人出现。
算命就是那个，他给我看八字，算命就是说我这个后半生财那么多。然后我看八字，然后2个人就是说我财那么多。
那挺好的。就是很福气。
而且我这个命很好，就是我的命。
很有福气。
而且你看我手小，然后肉鼓鼓的。
抓钱手，就很容易抓到钱。小胖手上那些有的牛，那市场有的好看。
没有。 他我啥也不求。我跟他说我不上班，我就不上班，他让我上班，我又不上班。多好呀！我在美国那我就这个地方，我就干点别的活。如果要是说真的找不到，他就给我推荐了一个工作，就是去学前班带孩子，也挺好的。
你去带孩子挺好的，你去学前班、幼儿园，
对呀，
去给他照顾小 baby，
对呀，
暖心挺
就
好。
3岁以下的，对呀，照顾。一开始是没有，
但是也不要操心。
你不用说教他什么，你就照顾他就行，就是保健保育员的活。
对，就是给他教他这
这
种那样。
几个孩子还不是特别多，
他们都穿尿片嘛，要不是只有拉个大便嘛，清洗一下也还 OK， 其他也不要别的磕碰。
对，小孩儿他可能一爬还有啥磕到碰的。
对，挺好的。
一个月有4个，至少。4、5天就不要再2、3天，3个月，2000就够了，我跟你说姐。
对，他不会，他会最低工资标准17块钱，17块钱1小时。
17块钱少，现在不是，现在是17块钱。
最低嘛，他不能低于17。
我前两天去他公司旁边的衣服，然后给我按16块钱一小时，3块。
但是很辛苦。
不辛苦，自己背回来。他不是按件儿算的，他是按时长算的。
哦，就慢慢叠。
就这些东西你叠完就行。
叠不完，然后明天再说。就叠衣服。
明天愿来就来，然后
叠 T 恤，明天。
一开始愿意来，后来就不愿意干了。他说我不干，你们找人。
为啥呢？
就是有3分钟热度。
他要每天上午去，一直到早上。
不是，他就是说有时候他回中国了嘛。回国时候他说他有活忙不过来，他说那你就找别人帮你干了。够没？老板付钱。他免费的。一个是1个月他是1个月他无薪的。我现在是15，我现在没有到10%左右，还剩5。
你现在不至于
还差5，
差一点点。你有没有什么预防或避免？
就是保管的再好，顶多让他就是原地踏步，他不会再往上升。
那你就注意点吃饭上，主要是吃的东西上。
我也不能吃太多蛋白质，然后我现在就注意力都不集中。
因为没有蛋白质，所以就会体质就会差。
然后我打游戏我也是。
我也是，我就是蛋白质不够，我不吃肉。
别吃肉。
所以我注意力不集中。
别吃肉。
别人跟我有时候说话说完就走神儿。
对，说话就走神儿。
因为蛋白质不够。
吃的优质蛋白，比如说牛奶、鸡蛋。
我不吃肉，现在。
Okay. Number 19. The answer. If you receive any summon, you can answer. If you answer after 1 month, just to trial, you can get more time. That's the didn't pay any rent, you can get the time. Answer on the container. The answer is simple. Defendant or defendant for whom this answer is filed must be named and must sign this answer unless their attorney sign. Answer the complaint as followed. 2. Denial, check only one of the next 2 boxes, just one. 8. General denial. General denial meaning is all the denial. That one is do not check this box if the complaint demand more than $1,000. Didn't pay the amount over $1,000, you cannot mark here. How you can that under the $1,000? That's terrible. Defendants generally deny each statement of the complaint and the mandatory cover sheet and the supplemental allegation under detainer form 101 UD 101. B. 100% mark here. B. Specific denial. Check this box and complete 1 and 2 below if complaint demand more than $1,000. More than $1,000. For 20 years ago, rent is just 305 or 100 something. At that time is available. But in this day, 1 month's rent around $2,000 and then $1,000 less, how we can? Defendant admits that all the statement of the complaint and the mandatory cover sheet and the supplemental allegation on the detainer form UD 101 are true except number 1, denial of allegation in complaint form UD 100 or other complaint for unlawful detainer. A. Defendant claims the following statement of the complaint are false. State paragraph number, form the complaint, or explain below, or if more room needed on form MC 025. Explanation is form MC 025, title as attachment to B. The defendant has no information or belief that the following statements of the complaint are true. So defendant denies. Then state paragraph numbers from the complaint or explain below, or if more room needed on form MC 025. Explanation is form MC 025, title as attachment 2B, 1B. Number 2, denial or allegation in mandatory cover sheet and the supplemental allegation on the detainer form UT 101. A. Defendant did not receive plaintiff's mandatory cover sheet and the supplemental allegation from form UD 101. If not checked, complaint and as appropriate. B. Defendant claimed the following statement on mandatory cover sheet and the supplemental allegation on the detainer are false. State paragraph under number 4 from form UD 101 or explain below, or if more room needed on form MC 025. Explanation on form MC 025, title as attachment to B. Next page, page 20. B. 2C. Defendant has no information or belief that the following statement on mandatory cover sheet and supplemental allegation on the detainer form UD 101 are true. So defendant denied them. State paragraph numbers from form UD 101 or explain below, or if more room needed on form MC 025. explanation is on Form MC025, titled as attachment 2B to C, something. 3. Defense and objection. Note, for each box checked, you must state belief, fact to support if in item 3T on page 3, or if more room is needed on Form MC025, you can learn more about defense and objection at www.coach.ca.gov/self-help and eviction HTM. 8. Non-payment rent only. Just a payment I didn't pay. That one. Plaintiff has a warranty to provide habitable premise. That one is plaintiff has breached the warranty to provide habitable premise. B. Non-payment of rent only. Defendant made needed repair and properly deduction the cost of the rent from the rent, and the plaintiff did not give proper credit. Normally 80-90% is Mark B. C. Non-payment of rent only. Date. Before the notice to pay or quit expired, defendant offered the rent due, but plaintiffs would not accept it. D. Non-payment of rent only. Plaintiffs' demand for possession is based on non-payment of rent due more than 1 year ago. E. Plaintiffs waive, change, or cancel the notice to quit. Number 8, no, not number 8, number D, non-payment rent only. Plaintiff's demand for possession is based on non-payment of rent due more than 1 year ago. E. Plaintiffs waive, change, or cancel the notice to quit. F. Plaintiff serves the defendant with the notice to quit or file the complaint to retaliate against the defendant. G. By serving defendant with the notice to quit or filing the complaint, plaintiff is arbitrarily discriminating against the defendant is violation of defendant or the law of the United States of California. H. Plaintiff's demand for possession violate the local rent control or eviction control ordinance of a city or county, title of ordinance, and date of possess. Also, briefly state in item 3T the fact showing violation of the ordinance. I. Plaintiff's demand to possession is subject to the Tenant Protection and Act of 2019, Civil Code Section 1946.2 or 1947.12, and is not in compliance with the Act. Check all that apply and believe. State. 어디 갔다 왔는가? H. Plaintiffs' demand of possession violate the local rent control or eviction control ordinance of city, county, title of ordinance, date of possess. Also, brief stating item 3T, the fact showing violation of the ordinance. I. Plaintiff's demand to possession is subject to the Tenant Protection Act of 2019, Civil Code Section 1946.2 or 1947.12, and is not in compliance with the Act. Check all that apply and brief state in item 3T. The fact the subject H. 1. Plaintiffs fail to state of just cause of termination of tenant in the written notice to terminate. 2. Plaintiffs fail to provide an opportunity to use to cure any alleged violation of terms and conditions of the lease other than payment of rent as required. Three, plaintiffs fail to comply with the relocation assistance requirement of Civil Code Section 1946.2. 4. Plaintiffs has raised rental more than the amount allowed under Civil Code Section 1947.12, and the only unpaid rent is the unauthorized amount. 5. Plaintiffs violated the Tenant Protection Act is another manner that defeat the complaint. That one is you don't need a mark or something. J. Plaintiffs accepted the rent from defendant to cover a period of time after the date notice to quit expired. One more. Plaintiffs accepted the rent from defendant to cover a period of time after the date the notice to quit expired. Now, K. Plaintiffs seeks to evict defendant based on act against defendant. Defendants immediate from a family members or members of defendant household. J. Plaintiffs accepted the rent from the defendant to cover a period of time after the date of notice to quit expired. K. Plaintiff seeks to evict defendant because based on acts against defendant. Defendant's immediate family member or a member of defendant household that constitute domestic violence sexual assault, stalking, human breaking, trafficking, abuse of an old elder or a defendant adult, or a crime that caused bodily injury, involved a deadly weapon, or used force, treatable force. This defendant requires one of the following, which may be included with this form. 1. A temporary restraining order, protective order, police report that is not more than 180 days old, a signed statement from a qualified third party. Example, a doctor, domestic violence or sexual assault, counselor, human trafficking, caseworker, psychologist, or a victim of violent crime, advocate, consummate the injury or abuse result from this act. Or 3, another form of documentation or evidence that verifies that the abuse or violence occurred. Number 1, the abuse of violence and committed by a person who does not live in the dwelling unit. 2, the abuse of violence was committed by a person who lives in the dwelling unit. The defendant claims protection from eviction on the Code of Civil Protection Procedure Section 1161, that points 3 D2. I. Plaintiff seeks to evict defendant based on defendant or another person calling the police or emergency assistance. Example, ambulance. By or on behalf of a victim of abuse, a victim of crime, or an individual in an emergency when defendant or the other person believed that assistance was necessary. And plaintiff's demand for possession of a residence property is based on non-payment or rent, other the financial obligation, and check all the applies. 1. Plaintiff received or has a pending application for rental assistance from a governmental rental assistance program or some other source relating to the amount claims in the notice to pay rent or quit. Today, that one is finished. Finish. Finish.
Yeah, thank you.
Today's finished.